Alright, I guess we might as well get started properly then. Welcome to session 2. You'll notice that today we do have a guest speaker, but before I get into that, essentially we want to do 4 things tonight. First, we are going to give you, with our lovely guest speaker, a lecture on what you shouldn't do. Basically, we're going to go over the common pitfalls to try and give you the benefit of our experience there. Then we'll go through the workshop of the problems you guys had from last fortnight. We'll have a bit of a discussion about how a moot actually goes down, the various stages you work through in a longer submission than the one you're dealing with today. And then we'll talk about the problem for the next fortnight, which is all about annoying Sam. So, moving on to the first one on what not to do, I'll invite our lovely guest speaker, Nigel Siegel, up here. I talked to you guys way back in the first lecture about how mooting is subjective, which means everyone has a different take on it. That's one of the reasons I'm keen to get guest lecturers. I'm not a guest lecturer. Involved in these sort of things. And when I thought of what not to do in mooting, Nigel came straight to mind. So Nigel has a fair bit of experience in mooting. He competed through the UWA in the Kerr the year before last. I think he's gone to ALSA for UWA a few times. He's made it to the semi-finals of IHL.
Yeah, that was
the thing, right?
Yeah, I think so.
Yeah. And you've also made it to the finals of open mooting twice.
Once, and came 4 out of 4. So
yeah,
it's good effort.
Lofty standards here, people. This is what we're aspiring to. Right, so as I said before, basically we are trying to go over all those little things which you'll do, which you don't even know are wrong, which will annoy the judge or just really get on someone's nerves. Mooting is subjective, which means a lot of what we're going to say, you can go one way, you can go the other, it's just our opinion. This sort of stuff is a little bit more black and white. If you do these things, you're more likely to upset someone, though there's still exceptions. So yeah, get the simple stuff right and worry about the other 50% after that. If you'd like to
I'd just like to comment about mooting is subjective and something will annoy people. I don't think there's anything wrong with saying to your judge when you go and speak, "Good evening, Your Honour," or whatever. But when I did that in the grand final of the open mooting competition, Justice McKechnie just went nuts at me. He basically immediately retorted saying, "Never say good evening to the court." And that was not a good way to start submissions. So I've never had a judge raise an issue with that. In fact, I feel like it's impolite not to, say hello. But anyway, some judges won't like it. Probably best to err on the side of caution. So that just goes to show that the different things you do might flow with some people and not flow with others. So it's probably best to just sort of play it by ear and see what the particular judges do with your opponents, I guess.
Yeah, I've had the same experience. When we were doing Jessup, we were told to always say good morning, good evening, good day, whatever. It was just polite. It's only since I got back here that I've been told that, no, actually you shouldn't do that. So, one of those things. So anyway, we'll go through sort of this various stages as you think about a mood, as you get up to the various parts of it, and we'll try and break down these tips and tricks into little manageable segments. So speaking first about what you do when you first get the problem and you start preparing your argument, whether that's written submissions, whether that's oral submissions, whatever it is. I think the first and most important thing you should do is make sure that you actually deal with the arguments and the cases that are on the other side to you. A lot of times you see first-time mooters just trying to put their own case as strongly as possible and overstating it or ignoring the limitations or just trying to sweep it under the carpet and hoping no one will notice. And that's about the worst thing you can do. And I guess related to that is the idea that you shouldn't make arguments with the idea that you're going to retreat from them if someone presses you on them too hard. Another thing you'll see a lot is someone will get up and make an argument and then the judge will say, "Is that right? What about that case?" And the person will say, "Oh yes, that's right. You're right, never mind. I guess I'll move on to whatever I have to say next."
If you can convince yourself that an argument makes sense and you actually begin to like the argument, it's probably a good argument. But if you look at an argument and you say, "This just does not work with common sense, but I think I've got a way around it," it generally won't be. The judges won't like it. And I think the best example of this was Sam's and Chris's Kirby team. I judged a practice round of that, and the argument that they tried to run was so obnoxious. It was the question was it was some issue to do with a solvent to remove paint or something off a tent, and the solvent had actually burnt the tent and damaged it beyond repair. And the argument being run in defence of this company being sued that had supplied the solvent was that in fact it had done exactly what it had been advertised to do because it removed the stains from the tent. Which was just...
You might have your own opinions on that.
It's just a rubbish argument, and no judge is going to accept it. So I guess that's what it means by the pub test. Just apply a bit of common sense to it, because the law is generally based on common sense. And those sorts of arguments you'll just be shot down on or completely sidetracked on, because the judge will just think that you're spewing shit. So, yeah.
And I guess I will put one caveat there, that sometimes you really do not have a good set of laws to argue with. Sometimes you're going to have to make a shit argument. Sometimes you're going to have to try and make some ridiculous argument fly because it's literally the only argument you have. It sucks. If you have to do it, you have to do it. Just really make sure that you have to do it before you actually get up there and try it.
I think it's Sam's line. I don't know where he got it from, but if the law's on your side, bang on about the law. If the facts are on your side, bang on about the facts. If nothing's on your side, just bang on the tape. So I've generally adopted that strategy.
And I guess our next big point is when you're preparing your argument, and this is related to the ridiculous convoluted arguments I know I'm sometimes tempted to try and run, keep it as simple as possible. If you have a choice between one argument, which is 2 steps, and the other argument, which is 18 steps and involves importing some weird doctrine from 1700s England, you're probably going to be better off going with the simple one, even if it doesn't appeal to you intellectually quite as much. And finally, this is more of an issue when you actually have to put together written submissions and then argue about them later. But when you do, try and limit the amount of cases you're citing in those written submissions. Generally for a moot, that's, what's open mooting, 20 minutes these days?
25.
25, it's increased. Generally for something like that, you would have 6, 7, 8 cases at most. You would have 3 or 4 on each submission and try and keep it in that. Sometimes you'll be able to cut it down a lot more if there's only a few really relevant cases. Sometimes you need to have more if there's a lot of really relevant cases, but just try and do what you can to keep it to a relatively small list.
In my first moot, I think I cited about 10 or 12 cases, and this was in first year law. Hadn't read any of them. So I got up there with my sort of paragraph excerpts from, the lines that I wanted to cherry pick out of each case. The first question that the judge asks is, well, what are the facts of that case? And I get to stand there thinking, I've got no idea on it, but I've got a copy here, you can read it.
Also not a great line. And that gets to the other point there, which is that you should, if you're citing a case, you should know it well, because the common sort of question every judge will ask if they don't have any other questions to ask and feel like they should earn their keep is, what are the facts of that case? How are the facts different to the facts of this case? Is the judge in the minority there, the judge you're citing? Has that case been overruled? All the basics sort of things about your cases. Make sure you know them. Make sure you've got an easy Word document or something that you printed out which lists the basics if you need to. Yes.
Can you just go as far as that case was about debt recovery in circumstances of the person being out of jurisdiction?
Yeah, if that's the only extent to which it's relevant, sure.
And again, all of this stuff, reading cases, understanding what's going on in them takes time. You're not going to have heaps of time. So that's another good reason to keep your case list very short. Even though some cases will cite a proposition in a nicer way, don't give yourself too much work and keep it fairly short and concise. But also do your research quite well, because often there'll be a couple of cases that if you go looking for them will directly address your point or be quite factually similar to the point that you're trying to address.
One thing I've learnt over the last couple of weeks is that we're lazy people, and when we go to write, say, a problem question for a moot, quite often we'll go to an earlier decided case we know that's a little bit controversial and just massage it a little bit to fit it into a problem question. Like, that's pretty much what we've done with that Lowndes, and case here. Right, so next thing we wanted to talk about, written submissions. I know this is Nigel's particular pet peeves.
Just make them look good. Go through and edit them. And don't come up with convoluted ways of formatting your submissions. They should be numbered beginning from one, and numbered paragraphs, formatting that makes sense. Use a list structure because it's far easier to read. Use plenty of space because judges like going through marking them. I've had moots where people have started the formatting from number 3, and it just makes no sense. In their mind it makes sense, but it just looks like they made a mistake. Spelling errors look embarrassing. And the problem with all this is, sure, everyone makes spelling, grammatical errors, but the judge will likely pick it up, and if they do, they just sort of start thinking, oh, this person's an idiot because he doesn't know how to spell, and they'll stop thinking about the argument you're trying to make, how good it is. So just make sure the presentation looks good. If you're competing in open mooting here or any mooting competition in WA, just use the normal Supreme Court format. Header looks pretty good compared to other states. Just do it professionally and get time to read over it, because if you're anything like me, you're trying to finish off your submissions at 3 or 4 o'clock in the morning before the moot, you're not going to have a chance to, you're going to be too tired to figure it out, so normally I'll just email one off to Sam or someone else, get them to have a quick read through and they'll tell me where I've stuffed up. Very helpful.
Yeah, absolutely. I guess we haven't given you guys any written submissions yet. We haven't asked you to put them together. At some point, we'll probably give you some examples and ask you to have a crack at something relatively short and sweet. When we do, we will make sure to give you guys some precedents to go off. Some good ones, some bad ones, some Nigels, which...
They're the good ones, obviously. The other thing I've said there is use precise language, and this applies to your oral submissions as well. If you're dealing with a civil law moot, breach of contract, that sort of thing, don't put in your submissions, don't start referring to things as crimes. People often do that in the oral submissions, and it's just, it doesn't come across well. It just looks like you don't know what you're doing, or well, you've got privilege in court, but it kind of seems like you're going out of your way to defame someone. Just use precise language and use the language of the cases as well. It just sort of makes it a lot better.
I've written there that we should try to write like humans and not like lawyers. You're probably, well, I don't know what stage you guys are all at, but at some point you're going to get sick of being told to use plain English and common sense drafting and all the rest of it, but it really does help. We get into this a bit more in the oral submissions, which is not next, so I won't go to there yet. But words like utilise, you never need to utilise. You can always just not use it. So little things like that matter.
Edit. If you go through, you can actually delete so many words. And for some reason, people think the longer their submissions are, the better their argument is, but that's just crap. Whoever's doing procedure, you'll know how annoying it is to sit through and try and read through procedure papers that crap on for 50 pages. Repeat sort of irrelevant stuff. It's just annoying. Respect the people who are reading it, because judges will often rock up and maybe have 5 minutes to look at your submissions. So if you make it quite short, punchy, get to the point, at least know what you're doing. Just don't crap on. And you can. The best way to avoid doing that is going through and editing, removing unnecessary words, just making it flow better. Shorter the argument, the better, I think.
Generally, yeah. So on the day of the moot itself, or whenever you get around to actually doing your final bits of preparation, always make sure you've actually had a read over the opponent's cases. Sometimes they'll cite some stuff which is pretty much self-evident and you won't bother, but it's always nice to have a look through and actually check the footnotes that they're citing to and the paragraphs they refer to.
Sometimes they'll completely shoot their own argument in the foot. It's brilliant. In ALSA, I was struggling with authority for this one proposition. I read their submissions, and they cite a case that if true, would have meant it was game over for me. I read the case. It turns out they'd actually cited the dissenting judge, and the other 2 judges had agreed with me. So Exhibit 1 in my argument became the case that my opponent had submitted, and they, because I was responding, they just looked like fools because they had cracked on for a long time, and about how this one judge had supported them, and my 20 minutes was reading out paragraphs of this case, shooting down their argument. It was just great. So read them.
Yes, Sam.
What happens in the case though where you have already done your written submissions and like aren't you not allowed to go outside the scope of those written submissions once you've already had them in, or is that just
they referred to cases?
Yeah.
So you can just say disregard submissions 1 to 3. I'm just going to talk about this case.
Well, if your argument, hopefully your written submissions are on the point anyway.
Yeah.
In this particular case, their case actively supported my written submission, so it went in nicely. But there's no restriction on you being able to cite authority or cases that the opposition says.
Yeah.
I don't think you should depart from your written submissions too significantly because then it looks like you're chopping and changing. But if you've discovered that one of your arguments is bad, for example, if your opponent's come up with high court authority that just completely shoots the argument on the foot, then perhaps reconsider making it.
So you just change the order of your submissions and try and discuss that authority in one of your other ones.
Yeah, it really comes down to the particular circumstances.
And I'm stressing it a lot, but really read cases. When you're in moots, read cases. I know as law students we don't actually like to do that an awful lot, but sometimes it can come back to bite you. I remember when I was doing Kirby with Chris last year, there was about 3 moots in a row where the opponent cited this one particular case, Bunnings in some federal court, which was about the only case on this, the way you interpret this particular provision of the Australian Consumer Law. And every team cited it wrong. And every time in my rebuttal I got to go up and throw the right paragraph at them and just do it again and again and again. And I think we actually won the final moot because they screwed up such a simple thing because they didn't read the case properly. So read the case, really helps. While we're on cases, it's generally expected that you'll have a hard copy of them to give up to the judge on the day of the moot. Some judges won't want them, some competitions will say don't worry about it explicitly, but as a general rule, if you don't hear anything otherwise, try and have a copy or at least of the relevant parts of it.
The problem with that, of course, is, again, if you cite too many cases, you're going to kill a tree printing it all out. 9 times out of 10, if you bring a nice bundle of authorities there, the judge probably won't look at them. The one time that they do want to look at them is probably the time that you need them. I generally don't bother, and that's just simply because I'm trying to save a tree. But if you get if you're in a pretty high-level competition or something, just put some effort into it, put it into a bundle, number all the pages, and if you've got, say, for example, 3 judges, if you put it into a bundle and you've got page numbers for your bundle, then at least you can say, well, if you turn to page 50, you can go to it and cite the relevant paragraph rather than stuffing around with 5 different loose leaf copies of the cases and just turn it into a mess. So a little bit of preparation there can be helpful.
So in that instance, you'd actually put page numbers for your bundle itself in your written submissions.
Generally, I'm stressing putting together the bundle on the last day, so before. But I guess if you're prepared, it's a good idea.
Just be aware that if you put it in your written submissions, it means that they probably won't have the bundle when they first start reading your written submissions. So I would stick to...
Yeah, sorry, no. Yeah, no, what you're saying makes sense. So you've got your own page numbering system and you just say, okay.
Yeah, it just makes it easier to make reference. The courts do it all the time now in civil trials, that you put all the relevant documents in bundles. It just makes it, during a trial, it makes it so much easier to follow through.
Yeah. Brushing up on the basics around things like who has the onus, who has the burden, that sort of thing can be useful sometimes. It's not very exciting stuff, but every now and then you'll get a question, you won't know how to answer it, so you'll just throw out something like, well, the other side is the onus of bringing that up and they happen to go away, and hope that they let you move on. Not the greatest technique, but sometimes it's all you have and it's useful as a fallback.
In one of the ALSA moots, the first question I got, I was all pumped for this round, get up there, and then some practitioners come down to judge it. And his first question was, it was an appeal to the High Court or something, on an interlocutory procedure or something. And he was quizzing me about what basis we had for bringing this application. And there was a rule in the competition that no procedural issues were meant to be raised. But this practitioner was genuinely interested and just sort of kept asking me, and I didn't have the answer. So it was very embarrassing. So I think the first question when you get these things is actually just know what section the appeal is being made under or whatever, or what the scope of the appeal actually is. That way, if you do get some oddball questions, at least you can answer it and not look like an idiot.
And related to that, one of the questions you'll often get asked right up front, particularly if your written submissions are unclear, is what do you actually want the court to do? What are you after? What remedy do you seek? And it's always nice to make sure that you actually have an answer to that, whether it's overturning a decision, sending it back down to another judge for consideration, upholding a conviction, whatever. Just try and make sure you know what you're going for. That's probably the most embarrassing question to not be able to answer. I think that was a final of ALSA, judged by Chief Justice French one time when he asked that off the bat and someone didn't have an answer. Not a good time.
I want you to sit there and listen to me.
Finally, just on notes, I know this stuff isn't particularly exciting. We'll get into the more exciting stuff later, I promise. But just don't... It's fine early days now, but by the time you get into open mooting or something like that, try not to have a fully fledged script in front of you. You'll find that you spend a lot of time staring down at it, reading it, and you won't know it as well as you do. It's much better to either write out the script and then reduce it to dot points, or just to have dot points or something like that as you go, and just go off that. You'll come across as a lot more engaging because you'll be looking at people, you'll be talking to them, you'll actually be altering what you say, depending on what they're doing, what's happened before. It just generally makes for a better mood. Right, etiquette.
Oh, I'm no authority on this. A couple of things. If you've got a moot coming up, probably best to go to the bathroom before the moot. There's been some odd situations with people getting up to do their moot and then saying, "Oh, can we have an adjournment because I need to go to the bathroom?" It's not a great look. Waiting. What's this first one? Waiting until everyone.
What I mean by that is, so you'll go in. You'll take your seat at the table, the judge will be sitting there, and the judge will be like, all right, what's your names? Start writing all that stuff down, and take appearances, they'll be writing it down. The first person will get up to speak, and the judge will still be trying to write down names and work out where they're at, and then the first person will just start going. That's not good. You want to wait for that moment. There's always that moment. The judge will be sitting there, and then they'll look up and give you the little nod. That means go. And you have the same thing happening for second, third, fourth speakers as well, where the judge will still be making frantic notes about how the last person went and where they went and how they thought they did and all the rest of that. And then the next person will just start talking and she'll be, oh, what's happening? And throwing papers around and trying to get into actually listening to what you're saying. So just wait until the court is ready.
Silence is a good thing often. I think people have some sort of fear about the room being quiet, when really it's a good thing. If you tell the judge to go to a certain page of a case and you've given them the case, you can see they're trying to go to that case, so you can point out a paragraph of your submissions. Wait until they get there. There's no point going off onto your next point. Let the judge sit there, absorb it, and they can actually ask questions. So I don't have a problem with waiting there for 10, 20 seconds or whatever while the judge is finding a relevant section. And just because it's silent during that time, it's not a bad thing. It means they're actually listening and paying attention.
And it's definitely a good idea if you are taking the judge to something to wait until they're there before you start talking and you can lose them again.
References to the other side. I like this one. I had one moot a couple of years back where I was up against an opponent who thought that he was going to beat me. And he gets up, I was responding, so I spoke after him. He gets up, and I don't think he'd done his research properly, but he was intent on attacking me. So most of his speech was saying, Mr. Seaguard says this, and it's completely wrong, and that, and the other. And it was being quite loud, obnoxious, fairly disrespectful. But what he was saying wasn't sensible, and so I won that one hands down. And I was very happy with that one because he was completely wrong. But not only was he wrong, he was being fairly obnoxious about in the style that he was delivering it. So no matter how good your point is, you should still be respectful of the other side. I think most people use the phrase "my learned friend," which I think is appropriate. But sort of grandstanding is not going to help you, and the judge is going to think you look like an idiot.
My learned friend is the most common way you hear people refer to people on the other side. You also sometimes hear it as the short and just "my friend," but I know some people don't like that one because it sounds a little bit condescending. Otherwise, you can always go for the old, counsel for the respondent, counsel for the applicant. Or if you're referring to the submissions themselves, you can just say the appellant has submitted X, Y, Z, and you don't really need to refer to the person. Also, you shouldn't point at the other side. That's not a good look. I've never seen that work. References to the judge. Obviously, they're a judge, even if they're just a make-believe judge. That means you want to treat them with the utmost respect. Typically, you'll refer to them as Your Honour. In some courts, it's Your Excellency, Your Worship, whatever. Whatever it is, stick with it, be nice. When you're referring to other judges as well, so you're saying, in this case, His Honour, Justice French said whatever. His Honour, Her Honour, Their Honours, usually put that in front of it. Sometimes if you slip up and you just say, Justice French said, or whatever, no big deal, just try not to make too much of a habit of it. Don't just call them French. That's
with Robbie. Another good tip, turn off your phone. It's a good one. And also,
so many times.
Also, I think just removing things that you don't need in your pocket, like your wallet, loose change, keys, makes you feel more jingles. Exactly, makes you feel a bit more comfortable, and also it doesn't make weird noises when you start moving around.
Back to dealing with judges. When they start talking, you stop. Doesn't matter if you're in the middle of the sentence, you're delivering the greatest debating point ever. If they open their mouth, or they even look like they're about to say something, stop. Let them say it. Wait for them to finish before you start talking. Don't start talking over them. And if they interrupt you again while you're starting to answer, even if they're just clarifying the question where you already knew what they were going to say, you still have to wait for them to finish. Sometimes that means you'll be standing there for 30 seconds while the judge asks a really long-winded question you could have answered after the second second. It's just unfortunate. The judge has his soapbox, and if the judge wants to use that soapbox to ask really long-winded questions an awful lot, you're stuck dealing with it. Just never interrupt a judge, never talk over a judge, and always watch for that moment when the judge is about to ask a question so that you can shut up preemptively and show that you're actually in a conversation with the bench, not just dictating to them.
Also, I don't have a problem with taking a little while to think about the question once it's asked. I think that's a better strategy if you don't immediately know the answer than blurting out the first thing that comes to your mind. And also, if you don't understand the question because the judge has put it in a weird fashion,
As they do.
If you need to, ask them to repeat it or rephrase it. It's not the best look, but it's certainly better than trying to answer a question that you don't understand. And often the judge won't. We'll get to the end of the question and think, I did not word that properly. So they won't actually mind rephrasing it.
I know when I've judged, there's been more than a few questions I've ended with. Did that make sense? Do you understand that? Because when you're starting to ask a question and you're just being barraged by counsel, sometimes it takes a moment to order your thoughts, and you'll ask it really long-winded, and then you'll ask it again much shorter, more concisely. So judges won't get offended if you didn't understand them the first time.
Maybe the third time.
Still. The other point is, sadly in Australia and as in the UK, we're not allowed to walk around the court and make points and walk up and just lean on the jury box and be like, don't you think that's all right, Sam? I'd love to be. I really would, but unfortunately we're not there, which means typically you're standing behind your lectern, wherever it is. You can move around a bit, you've got your hand gestures and your other things, but just don't go too crazy. I know I have this really annoying habit of whenever I finish a sentence or finish making a point, I'll shift the weight to my other foot, and then I'll finish making that point, and I'll shift the weight back. And I've had judges who just get distracted by that and then just sit there. You're all going to have your little tics when you stand up. I know the other thing I do is I tend to tilt my head to the side when someone's asking me a question, like an inquisitive dog. So you'll learn those as you move more and more and try to control them to some extent. Don't stand here like a robot just mooting, but find the place where it's comfortable and within that range, and you'll do your best. Right, oral submissions. There are a lot of words and phrases judges just hate. Not all of them, not all the time, but there are things that every time you say a judge somewhere, it'll be just not like it. I mentioned utilise before, that's one of them. The other one I see an awful lot, particularly in people who come from a debating background. They'll say, I feel, or I think.
I believe really pisses me off. I don't care what you believe, just tell me what the law and the facts are.
Yeah, that is exactly the response you'll get. Judges don't care about you. You're a vehicle by which facts and law and things are delivered up to them, and they don't really care what you think of any of that stuff which is going through you and making its way out to them. So it's always, if you really need to qualify something with telling them where it's coming from, the appellant would submit that. Though, honestly, I would just rather that you said, the law is X. Because you're standing up, you're obviously making a submission, so just submit it and cut out those words at the start.
Well, actually, I'll pick you up right there. When someone says the appellant would submit that, I think just cut out the word would, because it's by putting the word would in there, it seems like you might hypothetically be making the submission. You just say the appellant submits this, then that's actually what you're saying. Don't sort of conditionalise it and this other stuff, which is quite common actually. But I think if you put it directly, it makes a bit more of an impression.
I often find that when you do phrase it with like, it's the appellant's submission that the law is X, it always makes it sound like you're trying to distance yourself from that submission. Like, oh, I really don't like this point of law, but my client is paying me a lot to advance it and I've got nothing else, so I'm just going to put it out there and see what you guys think. That's why I prefer to just say the law is X. It's backed up by these cases. It sounds more confident. It's briefer. But again, subjective, different opinions. That's why he's here. Slow down is the other big thing you need to be aware of when you're giving oral submissions. You'll start to talk and you'll get nervous, or there'll be a point you really want to get out, or someone will hold up a time card and you'll realise you don't have very long to get out these 3 beautiful points that you've worded so beautifully in your script. You start to speed up, and you start to speed up, and you start to speed up, and then suddenly you're talking very fast and it's just a barrage of words and the judge is lost and everyone is lost and it's just very hard. So breathe.
I've seen Jessup Mooters put their, on the top of their page of their speech, the words very large in the header saying slow down. And I think that's actually probably a good reminder because when you start at the beginning of each page, you just you don't even notice it, but you tend to just speed up. And often a lot of these judges won't have read the question or won't have spent very long on them. During one of the ALSA moots, someone comes up and is just talking 500 words a minute, and the judge obviously hadn't had time to even read the facts of the case, so he didn't know what was going on. And after about 2 minutes, the judge interrupts and just says, "I'm sorry, can you just tell me what the facts are?" And this guy was about halfway through second submission by that time. So if you're not sort of paying attention to where the judge is at, if they're not sort of nodding in agreement or they're looking confused trying to find relevant documents, often you'll just need to just back up and take it through very slowly. And if you do that, they will actually start to clue onto your argument. And once they understand your argument, that's most of the way there to convincing them it's correct.
Yeah. The flip side is don't slow down too much. I had someone on my Jessup team in Canada who had a very slow, deliberate style of speech. And he made it work to a certain extent once he sped up a little bit, once we beat that into him because he had a very sort of concise way of speaking where there was no wasted words and everything was just precise and perfect, which might be why he took those extra few seconds to speak. There is a middle point. Everyone's is going to be different. You'll find yours eventually. Just be aware of it, I guess, is the advice we're giving. It's one of your favourites.
It is. It's a pet hate of mine where someone gets up and delivers a lecture on the law and that doesn't actually apply to the facts. The law is all very interesting, but when you're given a problem, it's really about how the law applies to those facts. You'll very rarely, if ever, have a fact situation that fits directly into one class of cases. So you should be spending a little bit of time on the law, and obviously depending on the situation, there's a controversy on the law, you might have to sit there and argue the law for a while. But so much of this depends on the facts. So your submissions, while they should address the law, should also just try and argue it on the facts as well. Don't just get up there and lecture on the law and then sit down, as I've seen so many people do. It's not what it's about. You really, your best bet if your facts are good are just argue the facts and make it persuasive.
Time limits. I don't know how we're going with ours.
Take your own advice then.
It's one of those things where you'll have a rough idea when you start. Okay, I've got 2 submissions in the intro, so a minute for the intro, 6 minutes, so 3 minutes for each submission, and that'll be me. And then you'll be there, and you'll see the 1 minute left to go, and you've only got you haven't even got to your second submission. I guess my advice is basically be aware of it, try to keep to it, try not to let the judge lead you too far astray, try not to get too distracted with too many anecdotes about all the horrible things you've seen while you're mooting with other people. And
most of these are my mistakes.
I haven't even got to the ones where I'm going to make fun of you.
When a judge asks a question, they actually just want to know the answer. One of my pet hates is saying, I'll tell you later, or words to that effect. I'm getting there, Your Honour. If they ask you a question, just give them the short answer. And if you're going to make the point later on, make the point later on. But just answer the question. For example, if the judge asks, have you read this case or have you considered this case? Just tell them yes or no. That's really what they want to know. If you have considered it, you can go on about the case or converse with them about the case. But if you haven't read it, there's no point making up excuses. Just say no. You can't be expected to have read every case under the sun. And it just lets you get on with your argument.
Yeah. And I think the easy way to do that is often a question will be yes or no. Your first word should be yes or no. So often the formula drummed into us is yes. Judge asks the question. Your answer is something along the lines of yes, Your Excellency, as was decided in this case, blah, 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 blah. Or no, Your Excellency, this treaty actually says it. Something like that. It's nice and simple, puts it up front and reminds you what you're doing. Finally, don't mislead the court. It goes back to what we were saying before about sweeping things under the carpet. Sometimes when you're on your feet, it's very tempting to just not deal with that one little inconvenient fact, that bit of law which gets into your way, or if the judge clearly hasn't read a case and they ask, is there any fact which distinguishes that case from this case? And you're like, well, there's one, but you probably haven't read it, he probably hasn't read it, I'm probably the only one who knows about it. Just don't go there. Even if you get away with it half the time, that means you'll get caught the other half of the time, and that is the worst look. Like there was one time in Jessup where someone said a treaty said something it didn't. It was this obscure treaty between these 2 countries that I don't think I even remember what countries they are. But I just so happened to have that page of the treaty in the back of my file somewhere. And to be able to stand up and wave the treaty around and actually no, it doesn't say that. It's just such a bad look.
Not to mention, when you get out in practice, it's a complete breach of your professional obligations and the Legal Conduct Act and all the rest of it.
So yeah, that's our basic lecture on all the little things that you should try to avoid as much as possible, and all the little things that we wish someone had told us in a neat little soundbite before we started. Any questions on any of that?
Glad I got the tonight.
Oh yes. One of the other things I'll add in retrospectively, don't repeat yourself too much. Sorry, I'll get to you in just a second. I want to tell a story. So, we're doing international humanitarian law. There was an issue with a drone strike on someone who turned out to be civilians. It happened at night. someone asked Nigel a question while he was mooting. Does it matter that it happened at night? Nigel's answer, it did happen at night, it was night, it was dark, the sun had set, the stars were out, it was night.
This is what happens when I didn't have an answer. and my brain went into some sort of freeze. And yeah, so if you don't have an answer, it's often best just to shut up.
Yeah. Sorry, question.
I described the statement, the bullet point said, know the basics on your onuses and burdens.
Yes.
What are onuses and burdens?
Onus is a proof. Burdens are proof.
So, the criminal context is easiest. In the criminal context, the prosecution bears the onus of proving an offence beyond a reasonable doubt, right? So that means the prosecution is the one who has to prove everything. They have to prove it to that standard. What we're talking about there is basically making sure you know whose job it is to prove each thing and what standard they have to prove it to.
And how about the burden?
I always forget which one it is.
The onus is who has to prove it, burden is to what standard. But it importantly comes up in mooting because often it's an appeal. Yeah, it's always an appeal, isn't it? And if you ask me now, what's the standard that the appellant needs to get to in the court of appeal or criminal appeal in WA, I've got no idea. And it's often a question to be answered by the judge. So just go off and check it before you get up to moot because it's actually the fundamental question for the court is what do you need to prove?
In a criminal one, at least,
Yes.
the appellant has to show there's been a miscarriage of justice. For a civil one, I probably should have looked that up myself.
There we go. It's something that's very easy to forget. Just make sure you know before you walk in.
The other way it can sometimes be relevant, you might have noticed from our problem questions, sometimes you really want a fact and it's just not there. You don't have any information one way or the other, whether it was, for example, night. It's very ambiguous. So sometimes you can get away with just saying, well, if it was night, that would help the appellant. It's the appellant's job to prove the case. They haven't shown it was night, so therefore you have no evidence it was night. You should just assume it wasn't, or something like that. It's not particularly elegantly put, but sometimes you can fall back on the burden or the onus if you really want to get around a particular point. Right. So, if there's any other questions? I think we've talked. Yes.
Can you ever say I submit, or is it always the respondent submit or the appellant?
Respondent or appellant? Yes.
So you never say I.
I would never say I.
Interestingly, Judge last night said that in Court of Australia it's I submit as opposed to.
I'm not against I submit. I probably use it more than I should.
This is one of those things where your mileage will vary. My view is that no one is ever going to pull you up for saying the respondent submits. Someone might get upset if you say I submit, so err on the side of caution.
I had a judge blow up when I accidentally said I submit at the beginning of like 4 sentences with only 1 sentence in the middle. I didn't say submit at the beginning. And it was my first ever moot, and he was just like, at the end, he's like, you don't need to say I submit that much. You say it like every now and then, but honestly, come up with different wording. And I was like, cool. Yeah.
The other practical thing that I wanted to say during the etiquette slide actually was first moot ever, get up to speak, and I thought I was going to be one of these cool people. It was a hot night, and I thought I was going to be pretty cool and not wear my jacket. Because everyone was wearing jackets and looked very formal, and I thought, no, I'm going to be different. Before I even start, get the first word out. The judge is, where's your jacket? Go put on your jacket. So that was a bad start.
Yeah, I did a moot with a guy and he didn't wear his tie, so he spilled spaghetti on it at dinner before the moot. And so he wasn't wearing it, and afterwards he's like, mate, you need to wear a tie. I love Jewish submissions and everything, but you have to wear a tie. And he's like, I spilled spaghetti on it. And the judge was like, it would have been better just to have the spaghetti tie on.
It's actually, I'm not sure if this is Western Australia as well, but if you're not wearing a tie, the court can't see you. Legitimately true.
Are you going to refer to that episode of Crownies?
No. Are you? Because you've just owned up to it.
I love the show.
Okay. I had another fun one actually where the judge's only bit of feedback to me was, counsel, are you sure about the font you used in your written submissions? So another don't is don't use anything but Times New Roman apparently because they're going to notice.
Calibri is fine. Times New Roman or Calibri, you're pretty safe. Arial, I guess.
It's got too many curves in it. You probably
So you can see we're really getting down to the exciting stuff.
Oh,
today.
absolutely, yeah.
And I guess that really goes to drive home the other point here, which I made a little bit at the start. This is so subjective, which means you have to accept that sometimes judges are going to make stupid decisions, decide against you for stupid reasons, give moots to other people, even if you think they're ridiculous and incompetent and they should never have got anywhere near that was rightfully yours.
This is most of my life right there.
And that continues right through to practice as well, so it's a joy.
The only other thing I'll say is you see it so often in the open mooting competition, but everyone puts these summary of facts at the beginning. The worst one I've seen was someone who managed to turn the facts themselves around for 2 pages, and someone managed to run it for 3 pages with a summary of facts at the beginning before a submission. I don't know how you turn 2 pages into 3.
By saying it was night.
As a general rule, I wouldn't put a summary of submissions in there because the case is so short. The facts are so short that they might as well just get it straight from the material facts. Where you would include a summary of facts would be, for example, in Kirby, where you've got 50 pages of documents, you might consider it appropriate there to at least summarise what's happened so they don't need to trawl through 50 pages. But generally, open moot, I don't see any point, and it just wastes time if everyone's got their own separate spin on the facts.
Again, sometimes judges will want it, but I agree with Nigel's essential point. I don't think it's particularly necessary most of the time. If you want to include it, at least make sure it actually is a shorter summary of the facts and not just copy-paste or making it longer.
I have heard from some judges that you can actually use the summary of the facts to your advantage somewhat in terms of what you select and what you emphasize.
Spinning it.
Yes.
Yeah, it's not necessarily a matter of spin, but I mean, if you think of how you would do a pleading procedure, for instance, you can just say here's all the really important things which I'm going to be applying the law to, and you can actually refer back to that in your summary of facts. Be look, in my summary of facts, at fact 17, or it's not going to be 17, but 7. The most important point here was permanent full-time contract. I want to talk about that more in the context of this piece of law, right? So you can use that to your advantage. Yeah.
The way I would do it is, depending on what it was, obviously, but I would put the emphasis more in the submissions.
Yeah.
And just refer back to the material facts, also the actual fact sheet.
Yeah.
And just put that spin, because by removing the summary of facts, you've got more space and more time to go through and deal with it in the context of each submission.
Mm.
Right. We should get into our workshop then. Now we have 13 of you, which is a slightly awkward number. So,
Fortunately, there's 3 of us.
okay. I can't do maths.
That's
Spell
groups,
it out for me.
that's groups of 4 if we want to, Sam. Don't worry.
Right, groups of 4 then. Make sure that Sam, because I think you're the most experienced.
No.
We're the loudest.
Yeah, you're the loudest.
By no means the most experienced.
Yeah. Anyway, if you guys, bar Sam, want to split up into groups of 3, and then one of us will go along with each one, we can take it in turns going through this. Intended. And then we'll talk about the problem for next fortnight at the end, which will be another great one I'm sure you all love. And then we can go do whatever it is Chris has planned for tonight.
Oh, yeah.
Right, don't get your hopes up.
Don't worry.
Right, so in terms of submissions, the reason I'm going through this is because for next fortnight we want you to put together some slightly longer submissions, and it is very helpful if you have a better idea of the structure of that so that you can structure it well and you can present it as more structured. The more structure you have in a moot, the easier it will be for you to go through it, the easier it will be for a judge to go through it. So I'm basically going to go through each of those little subheadings there and try to offer a little bit of guidance. So the first thing that would happen in most courts is you all come and sit down and the judge will ask for appearances. That's where usually the senior person on each side will stand up and basically introduce themselves and the junior to the court and say who they're appearing for. So the common formula is something along the lines of, "May it please the court, my name is Samuel Pack and I appear with my learned junior Nigel Seagwart for the prosecution." And and then you sit down. The defence will stand up and say the same thing. They'll sit down, and the judge will look up and be Mr. Prosecutor, and then you'll go and stand up and start your submissions. There's no magic to that particular formula. Any variation where you respectfully say who you are, say who the person sitting next to you is, and tell them who you're there for, you'll be fine. The first thing you want to say when you stand up is, depending on where you are, if you're the very first speaker, you probably don't actually have to introduce yourself or who you're there for again, but generally you remind the court what you're there for, who you are, what you want, and who will be covering what. I've given the example of my Jessup submissions there, just because my Jessup submissions were workshopped to death, so I know that they cover the structure fairly well. It's way more elaborate than you need, but so for example, I was basically saying, "Hi Court, my name is Sam, I'm here for these people, I'm going to be talking for this long on these 2 points, then the person next to me is going to stand up and talk for this long on these 2 points, and I also have to reserve a minute for a surrogate, but that's a Jessup thing." The point I want to make there is that you should always, always, always roadmap at the start what you're actually going to deal with in your submissions. So that is, I'm going to deal with 2 points, 1 and 2, turning to my first point. And that is so that, again, the judge basically has these little mental headings in his mind so that you can follow those. And I had another reason, I forget it, but it's good. Do it. Sometimes it would be useful to have a theme, sort of the overarching, this is why we're here today, this is what you need to worry about, trying to put the particular matter in context. Again, I've got my Jessup one there, with the joy of international law. It's most useful to have those sort of things, I find, in the policy style questions. So, for example, the Lowndes and Wood one, you might have stood up and said, this case is about what we're going to require a doctor to do, whether there's a duty to rescue, whatever, and you're going to try and frame that issue in terms that ends up with you winning it.
I had a fun one, actually, speaking of that, I had a fun one on Monday, because Sam and I are of the same opinion that a little bit of narrative at the start is actually quite nice. It gives some context to your submission, so you're not just standing up there and talking about law and facts, but you've got a story behind what you're saying. I got about a line and a half through my story at the start about why companies should be able to trust their employees and why their employees should be able to steal their secrets and make money off them. And the judge just leapt at me because it's the Jessup style of Western Australia that you don't have that in fact it's all about the law and the facts. But the good news is that because you know that intro so well, as Sam would have, and because you know exactly where it's going as well, that makes you seem really, really great from the start. You just say, oh, well, this is exactly about my submission, which goes towards why a fiduciary duty, and the breach of that means that I'll be able to show you this in this case. It leads you into your roadmap, even if you get questioned at the very start, and shows the judge that you're absolutely ready for that questioning as well.
And that's exactly it. Like, this particular intro, because it was workshopped to death, we tried to make it so that there were less points at which a judge would jump on you and say, aha, but aren't later you going to talk about this, or something like that. So you need to watch out for those, because judges do like to interrupt narratives at the start. That sort of a narrative is way too long for anything you guys are going to be doing in these particular workshop series, but I was trying to give a general idea of it, and I'm not a fan of the style that there's only the law and the facts and that we should never put it in context. I think that is a mistake, but again, it's subjective, so that's just my opinion. Getting to the submissions then, and also transitions, which I'll talk about in a second. This is obviously the heart and really the meat of your moot. The most important thing, I think, is to continue your roadmap as you go through. So, in my example, I would say, so first I'm going to talk about why there's no transboundary harm in the Malachi Gap, or whatever it was. Because that made sense to all of you. And so I'd say, all right, turning to my first argument, I have 2 points in this submission. First, that we comply with our duty to prevent transboundary harm, and second, that we comply with the Malachi Gap Treaty. Turning to that first point, and then I would get into the transboundary harm. And I find it's useful also to have what I call transitions, which are those nice little neat phrases or ideas which allow you to get from one point to the other, or from one submission to the other. Because there are some submissions where you'll get bogged down because the judge just does not agree with you, and you'll get stuck there forever and ever and ever. And before you know it, you've talked for 18 minutes about environmental impact assessments, and no one's getting any the wiser. So it's useful if you have a nice little transition which will get you out, an escape hatch to get you into your next submission. So for example, in the Jesuit speech there, the way I got around the issue of transboundary harm, which my country just lost at because we killed off an entire fish species which was integral to another culture's religion and culture and economy.
New monster.
Yeah, we were the bad guys. The way I got out of that was basically by saying, okay, I've engaged with that, but now let's talk about how the Malachi Gap Treaty affects all of that. And there was this nice little transition which got me out of that and really let me move through and not spend 20 minutes talking about environmental impact assessments. Final point then is conclusion. It's nice to have a conclusion. A lot of the times you'll get so hammered with questions you don't actually get to have one, and you just have to answer a final question, your time is up, and you sit down. Basically, if you do get the chance, you end by summing up the points you've made, and if someone else is coming after you, reminding the court that someone else is coming after you to cover those particular points. I do find it's useful to have in your mind or on the page a longer conclusion if you have time, and a shorter one if the judge says you can have 10 seconds to conclude, which they often do, thinking they'll be generous. So you just try and tie it back in, remind the judge of your submissions, and if you can, tie it back into that theme and narrative that you had. And yeah, so that's a very brief run through of the structure of submissions. Any questions? Anything yes?
Will this pop up in email to us?
Yes.
Okay, that's good.
Yeah. No, this will, as for last time, all of this is going to be online.
I will resist the urge to throw my Jessup speech up there as well, as much as I want it to be useful to someone again.
All 30,000 words worth of them.
I got it down really short, honestly.
Did you?
Yeah.
Chris, have you got this up on a website somewhere? Have you got like an LMS page or something?
LMS is perhaps
Facebook.
dreaming, shall we say, but yes, Facebook
group
exists.
is now open, so I don't think people need to request permission to join it anymore.
It's not a private club anymore.
It's, no,
We let anyone in.
but you're all special.
Both of those things are true. So finally, talking briefly about what we're doing next section, which I believe is here again.
No.
So that's wrong.
Law Lecture Room 1.
Law Lecture Room 1.
There will be another event for it. What I want to jump in at this point is, of course, there's a couple fewer people here than last time. What I wanted to get, because decisions are made by those who show up, is a show of hands. Would people like this to be earlier? Yes? Okay, and no would be most other people. Right. I think that might have been representative of the people who showed up. Okay. We're constantly thinking about, of course, since it's the first time it's run, how we can do it better, how we can attract people and so on. But from that, we'll discuss it.
So if you guys have any suggestions on that front, all ears, particularly Chris, he's much more sociable than I am, likeable, charming, all sorts of things.
If any of those are true, please let me know.
See, look at him go. Right, so next fortnight. The basic aim is to get you to do a slightly longer version of what you did today. What we want is to do appearances at the start, because we don't expect you to actually work out a senior and a junior for any particular point. There isn't even a senior and a junior to the question. We'll just ask you guys to do appearances at the start and then round robin get through it. The aim is, with the question, you'll have two separate submissions, so you will have to balance a little bit of the roadmap, structuring it at the start, deciding which one you're going to deal with first, which one you deal with second, and getting that transition from one to the other. And I don't know the extent to which the other groups had questions, but we'll try and introduce those a little bit gently, nicely, without trying to scare anyone. So, the lovely question.
Just jumping on this, given it's quarter two, might be a good idea to just publish the questions so people can look at it. Unless you're
Depriving you of your spotlight.
It is depriving me of my spotlight. It's a lovely
had an hour and a
question.
half, that what you want.
I want Nigel not to have stolen the first quarter of it. And for you to have not talked for 10 minutes at the end.
That's true as well.
No, did we have anything planned for after this?
Yeah, certainly. I mean, I'm pretty keen to go across and have the nachos at Broadway because the cheese is fantastic. If anyone wants to join me, I'm more than happy to have you along because I would like friends at this stage. As
Show
last
of
week.
hands, who wants to go grab a snack?
Hey, good. That's
people.
at least
That's
people.
lovely.
Excellent. Good.
All right, so I will deprive myself of the spotlight.
Yeah, let's. I'm
Yeah.
hungry.
Very briefly, basically, there is a scenario where someone has made some rather outlandish claims about something. Someone may or may not have believed them. Someone may or may not have lost money as a result of believing them. First thing you need to deal with is whether there actually was misleading or deceptive conduct, and secondly, whether the person actually was misled or deceived by it. There is reference to the relevant sections of the law. Don't worry too much about cases. If you want to go up and look out for a few of the more big ones, go wild, but it's not a question that you should have to delve too far into the case law. This is more about application to the facts and those things. So yeah, let's go get nachos.
Yes, sir.
Can I just steal your captive audience for
Oh,
one
please do.
moment? I thought it was great. I didn't want to be captive yet. My name's Sarah.